Robby, what is on your radar today?
Well, Brianna, former President Donald Trump is ineligible to run in the Republican presidential primary and ultimately to run for president, according to yesterday's incendiary decision by the Colorado Supreme Court. Now, there are many reactions one could have to this surprising, divisive 4-3 decision, which will be appealed to and ultimately decided by the 9 justices of the U.S. Supreme Court. But one thing is abundantly clear. The anti-democratic agenda of supposedly pro-democracy political figures has been nakedly exposed for once and for all. Now, recall that for months, for years, really for as long as Donald Trump has been a serious political figure on the national scene, we have heard warnings from Democratic officials, from the mainstream media, political scientists, historians, everyone else who forms the expert class, that Trump represents an existential threat to democracy. According to them, this was true before Trump became president, it was true while he was president, and it was especially true after he exited the presidency in a fit of inchoate rage. The unique danger posed by a second Trump term in office, were Trump to return to the White House in 2024, meant that the rules were going out the window. His opponents are determined to stop him at almost any cost. Indeed, Trump is facing numerous criminal indictments at the state and federal level connected to his fruitless and ultimately counterproductive efforts to remain in power after the 2020 loss. But yesterday, the anti-Trump legal movement pulled off the first step of a coup to bar Trump from seeking the presidency again at all. Let me say that again, a coup. That's what it is. Let's be clear. It's a coup resulting from a decision by a progressive legal group, Citizens for Ethics and Responsibility in Washington, to use entirely unprecedented means to keep Trump's name off the ballot next November. Crew and various legal scholars of both a liberal and also a never-Trump Republican variety have tried to argue that Section 3 of the 14th Amendment to the U.S. Constitution prohibits insurrectionists from holding office, and that this provision applies to Donald Trump due to his actions on and before January 6, 2021. Now, it's universally accepted that Section 3 was intended to apply to former Confederates who had betrayed their oaths to support the Constitution by taking up arms against the United States. Whatever one thinks of Donald Trump and his foolish antics on and before January 6, the president's oath is to preserve, protect, and defend the Constitution. Moreover, Trump has never been convicted of inciting an insurrection, but according to Colorado justices, who, by the way, were all elected by Democratic governors, it's up to the candidates to prove his innocence, and thus his eligibility, in the same way that candidates for president have to prove that they were born in the U.S. and have reached 35 years of age. Now, I won't pretend that this legal case is crystal clear. We are obviously treading in some very murky waters. A lower courts judge, for example, ruled that Trump did in fact engage in insurrection, but that Section 3 did not apply to the office of the presidency. But look, there's a broader point here, and it has nothing to do with whether there's some technicality upon which a partisan and weaponized justice system could conceivably rest its singularly focused prosecution of Donald Trump. You are free to think Trump is unfit for office, and you are free to think the legal system should hold him accountable. But you cannot wrap yourself in the cloak of democracy when you resort to anti-democratic means to stop him. Democratic Representative Adam Schiff is celebrating the ruling, saying that it's accountability for Trump's past actions. That's dead wrong, Congressman. Accountability would be the voters rejecting Trump due to his actions. If you take away this choice, you've only proved you don't actually believe in the principles you've sworn that Trump has violated. Let's make no mistake, refusing to print Donald Trump's name on the ballot would be deeply, profoundly undemocratic. Trump is not a gadfly candidate. He is the current frontrunner. He is at this moment leading incumbent President Joe Biden in swing state polling. If the election were held today, he might very likely win. Are his opponents saying, we can't beat Trump, so it's okay to cheat? What does that do to their argument that it's Trump who won't play by the rules of democracy when they have gone to the court to beg the justice system to take this choice off the table for the American voters, who I suppose are too stupid to decide for themselves? And Trump is the threat to democracy? I can't put it any better than libertarian former Congressman Justin Amash, who writes, quote, "The opinion of the Colorado Supreme Court is shameful and runs completely counter to our constitutional system. Donald Trump was not removed from office by Congress for engaging in insurrection. Donald Trump has not been criminally convicted in a court of law of engaging in insurrection. Whatever you believe about whether Donald Trump engaged in insurrection has no bearing on whether he's eligible to run for president. No legislative, executive, or judicial body of a state should engage in extra-constitutional decision-making to disqualify a federal candidate from the ballot. This isn't accountability. It's an assault on due process of law. It undermines our electoral system and threatens every federal candidate for office. End quote. Now, for what it's worth, this effort may ultimately help Trump. That's because there's practically no way on earth that the Supreme Court will co-sign Colorado's recklessness. If they did, it would tear the country apart. It would tell millions of the people that they were not allowed to cast their ballots for their preferred candidate. This would erode faith in our institutions to an absolute breaking point. It would embolden anti-democratic forces, as it would expose our democratic system as fraudulent. Political figures who swear that Trump is a depraved maniac are demonstrating they need to look in the mirror. I am reminded, actually, of the pivotal scene in the Star Wars prequel movies, where the hypocrisy and hollowness of the Jedi commitment to democracy is exposed for Anakin Skywalker to see, resulting in his transformation into the sinister Darth Vader. If our elected leaders, our keepers of the peace, our protectors of the law, if they don't trust democracy to prevail over evil in the long run, if they must corrode and corrupt democracy because one outcome or another is too dangerous to be permitted, then they are the ones who have betrayed their oaths to the Constitution.
All right. So, as I said in our A-Block segment, I think it is wrong to decide without a trial court, without a fact-based finding that Donald Trump has in fact committed an insurrection. To me, that's the flaw in all of this. I also agree that completely outside of the law, the optics of this are bad from a Democratic perspective, just as they are bad when the Democratic Party keeps every candidate not named Joe Biden off the ballot in Florida. However, the idea that this is pure legal fiat, I think, goes too far. Much like deciding whether or not someone is 35 and therefore ineligible to be president, or much like deciding that they were not born in the United States of America and therefore are ineligible to be president. The 14th Amendment is clear on this prohibition of someone having committed an insurrection not being allowed to be president of the United States of America. That is a toggle yes, no, on, off switch. The Constitution is clear about this prohibition. I don't think, if we can take a step back from Donald Trump for a second, that anyone thinks the idea of that prohibition is a problem. Many conservatives in this moment are pointing to the fact that this is a law that was contemplated in the wake of the Civil War. That is true. But like most laws that are provoked by some real-world occurrence, they are not designed to be limited to apply to exactly that literal occurrence. They would not have promulgated the law if they thought that the law only applied to Civil War, right? There's no point. The Civil War already happened. So I find myself reflecting on the two conservative Federalist Society lawyers who have written a law review paper on this question, and there was a article write-up on it in the New York Times that came out over the summer. And they came to this, they say, as originalists, this is not a constitutional law review strategy that I agree with, but they are originalists, they are conservatives, they are Federalist Society people. They came to this question genuinely wanting to know the legal answer. And their assessment was that there are legal grounds for this. They say, they take for granted that he committed an insurrection. That part of their analysis I would quibble with. But they say that the provision in the 14th Amendment was written in a way that is broad. They looked at the historical context in which it was written and say that it, of course, contemplates a former president making the choice to try to undermine the political will of voters to remain in the presidency, that there's not a lot of controversy around whether that is something that is a insurrection or a coup or whatever the full language of the 14th Amendment is. Oh, here it is. It bars those who have taken an oath, quote, to support the Constitution of the United States from holding office if they then shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. So I do think that there is a bit of a conflation here that's happening. Is there a political problem here? Is this an optics problem here? Did Donald Trump, through his behavior, get us into a place where he has violated the law in such a way that might preclude him from legally being able to be president? Yes, but the accountability here should be at least as much on Donald Trump and him putting him and his party and his supporters in this position as it is on a provision of the Constitution that is what it is, that in fact is there to safeguard the American public from having people that would not respect the outcome of election results be in a position to, frankly, do that again.
I mean, but the ultimate safeguard has to be the people rejecting that person of their own free will. And look, I hear you, and I'm not, and I hope I made clear in what I said, I am not saying there's absolutely no legal case for doing this. There clearly is. Smart people have articulated one. I understand the argument. I would quibble with whether Trump's actions are bad. Again, I've said I supported him being impeached and removed from office over them. I think whether his actions to remain in power constitute an insurrection or rebellion that, to my mind, summons deliberately violent means or the taking up of arms, which was not part of the Trump scheme that we both consider to be the more compelling stuff that he did. I would quibble with that because I think they were in fact specifically talking about Confederate officers, people who had taken up arms. There's the question of whether, given the way Section 3 is worded, did they mean to apply it to the presidency? Because if a state disqualifies a state official, federalism, I mean, there's more, that's more understandable and permissible, whereas this is essentially a state disqualifying this person, like, for the entire nation, which is also a different thing and why the presidency might be accepted. So anyway, there's so many, it's debatable. It's clearly debatable. Given that it is not 100% airtight, I think you have to leave the choice to the people.
Look, this is all I'd say.
Which I know we're just having a discussion
this is all I say is that I could also say, well, let's let the people decide if someone's 35. Clearly, Olivia Rodrigo is not old enough to be president. But Americans know that, and they're smart enough to just choose not to vote for Olivia Rodrigo. None of us would allow that. We could say, oh, it's clear that, sorry, Cenk, but Cenk Uygur is not eligible to be president because he wasn't born in the United States. Maybe we should get rid of that law. But today, he's not eligible to be president. So let's just trust the process, and he can be on the ballot, and we'll just trust Americans not to vote for him despite him not being eligible because he wasn't born in this country. But that's not the logic we would apply in those scenarios, and everybody listening to this knows that. So this cannot be, I understand emotionally the political implications of this and the optics of it. And I agree that they're not good. But we would not be making the argument that it's anti-democratic not to just let Olivia Rodrigo shoot her shot if the law on the books
Cenk
is
Uygur
so
did
clear.
come on the show and argue that it was anti-democratic not to let him run for president.
Yeah, sure.
No, I hear you.
Yeah.
Well, I'm sure we'll be continuing to discuss this many times over as we wait for the Supreme Court to possibly take up this case and give us clearer guidance. More Rising right after this.